Welcome to Unwiring Tech, the podcast where I unwire about the social dimensions of digital ecosystem and emerging technologies beyond the buzzwords. I'm Ranjana, your host, and today I'm here to talk about something heavy but very important. How technology, especially AI and digital media, is being misused to cause harm. From deepfakes to online stalking, tech-based violence is becoming more common and more complex, particularly for women. And here is what's important to note. While the tools keep evolving, our system for protection and justice, not so much. In fact, the lack of strong redressal mechanisms is making our digital spaces feel even more unsafe. So in this episode, I'll explain what is happening, who it's affecting the most, and what needs to be changed. As digital technologies, whether social media platforms or advanced AI tools, become more embedded in our daily lives, they're also being misused in deeply harmful ways. We are seeing a rise in things like deepfake pornography, identity theft, and the non-consensual sharing of private content. And the truth is, the digital world is becoming especially unsafe for women. Now, on paper, India does have a pretty solid legal framework. The Information Technology Act 2000 and various new rules and policies are supposed to offer protection. But in practice, there is still a big gap between what the law says and how it is actually enforced on ground. Just look at some recent incidents involving influencers in Assam and ordeal of a women advocate in Tamil Nadu. These cases involve targeted online abuse, doctored content, and a complete breakdown in timely response. These stories offer a sharp lens into both the evolving nature of tech-enabled harm and the institutional roadblocks to justice. Let's start by the case of female influencer in Assam that really brings home just how dangerous AI-driven cybercrimes has become. It all started with a viral social media account, one that posted explicit content and quickly sparked speculation. Was the person in the videos real or was it all AI generated? However, following the arrest of the accused, it turns out the entire profile was fake. He created a fake social media profile of the influencer and uploaded her morphed images. The accused had used powerful generative AI tools like Midjourney and OpenArt AI to superimpose a real woman's face onto pornographic images and videos. The manipulated content falsely linked her to the adult film industry and even to a well-known international performer. What's worse is that the account, managed entirely by the accused, grew to over 1.3 million followers on Instagram and was monetized on adult platforms, turning the exploitation into a subscription-based adult platform for financial gains. While police acted promptly using IP tracking and device seizure to identity and arrest of accused, the case reveals deeper systemic gaps. Notably, the initial FIR registered mentioned not the Information Technology Act 2000, which contains specific provisions addressing digital privacy violations and obscene content. This choice of legal framework raises concern about enforcement capacity and legal literacy in handling tech-enabled crimes. Accused actions, while clearly involving AI manipulation and impersonation, it was not booked under relevant IT Act sections like 66E, which talks about violation of privacy, 67, publication of obscene material, or 66D, cheating by impersonation, despite the nature of the offense. The case highlights not only the unregulated accessibility of generative AI tools, but also the urgent need for better alignment between evolving technological threats and the legal instruments used to counter them. This mismatch raises serious questions about how well equipped our legal system is to deal with the new age cybercrimes. So what we are really seeing here is a dual problem. The unregulated ease of access to AI tools on one side for any malicious purpose, and on the other, a legal and enforcement system that hasn't quite caught up with how technology is actually being misused. Now let's talk about another case from Tamil Nadu, which is an example of how devastating even the more conventional forms of cybercrime can be when the system fails to respond. A women advocate experienced a serious violation of her privacy when some personal images and videos from her college years were leaked online without her consent. The content spread quickly across social media and private messaging platforms, and like in many such cases, she only found out after the damage has already been done. She filed a police complaint on April 1, naming the primary perpetrator and the admin of a WhatsApp group that had been circulating the content. But filing the complaint was just the start of much longer battle. Recognizing the scale of the harm, she reached out to Ministry of Electronics and IT in June. Her request was straightforward. Ask all relevant digital platforms, website, telecom providers, even adult content sites to take down the content using available tools like hash matching, photo DNA, or AI-based detection system. However, her appeal was met with inaction. With little choice left, she had to move the Madras High Court in July 2025, urging them to step in and direct MeitY to ensure that the content was removed within 48 hours. This case highlights something really crucial. Even when survivors try to go through official channels, and even when technology exists to help, the system often fails to respond with urgency and empathy that's needed. And that delay, it can be just as damaging as the violation itself. What makes this case even more unsettling is that the woman involved wasn't just any ordinary user. She's a trained legal professional. And yet she had to take the matter to court just to get something done that should have been handled through regular administrative processes. Her case clearly falls under existing laws, specifically Section 66A and 67A of the Information Technology Act, which deals with privacy violations and circulation of sexually explicit content online. But even with clear legal provisions in place, the system failed her. Yet the breakdown of intermediary accountability, the inefficiency of automated takedown mechanisms, and the inadequacy of the National Cybercrime Reporting Portal forced a victim with full legal knowledge to battle the system for basic redressal. It's a sharp reminder of a larger systemic gap. We have built institutions like Indian Cybercrime Coordination Center (I4C) and the National Portal to offer quick and accessible help. But if these platforms fall short for someone who knows the law inside and out, imagine how much harder it is for an average person, someone without legal training, digital literacy, or access to basic resources. At the end of the day, this isn't just a failure of enforcement. It's a failure of accessibility, accountability, responsibility, grievance redressal mechanisms, and empathy. Existing laws can to a large extent cover these crimes, but whether it reaches people in practice, that's still a question we need to answer. So let's take a moment to look at the bigger picture. Does India have laws to deal with tech-based abuse, especially against women? Absolutely. On paper, the legal framework is quite solid. The IT Act 2000 lays out a bunch of relevant provisions. For instance, Section 66C covers identity theft, 66D tackles impersonation using digital tools, 66E prohibits capturing or sharing private images without consent, Section 67 and 67A deals with the transmission of obscene or sexually explicit content, and these come with tougher penalties if the offence is repeated. 67B criminalizes any material involving child sexual exploitation. And then there is Section 77B, which classifies many of these as cognizable offence. And that's not all. In 2021, the government introduced the Intermediary Guidelines and Digital Media Ethics Code rules. These rules say that platforms like Instagram, WhatsApp, X must publish clear terms of services, remove obscene or harassing content, and assist law enforcement agencies when asked. They are also supposed to resolve user complaints within 72 hours. Further, significant social media intermediaries with over 5 million users must appoint a chief compliance officer, a nodal contact person, and a resident grievance officer. Plus, they need to publish monthly compliance reports so users know how seriously they are taking these issues. In 2022, amendment introduced grievance appellate committees to allow users to appeal intermediary decisions, offering an additional layer of oversight. Meanwhile, the Ministry of Home Affairs National Cybercrime Reporting Portal provides an online interface for reporting offences, particularly those against women and children. Capacity building programs under the Information Security Education and Awareness project have also been rolled out to raise awareness through workshops, e-learning modules, and handbooks on cyber hygiene. So yes, the legal architecture exists. The challenge, as we have seen, is in how these laws and rules are actually implemented and whether they serve the people they are meant to protect. Despite India's robust legal framework under the IT Act and intermediary guidelines, the cases of Assam influencer and Tamil Nadu's advocate expose severe shortcomings in enforcement and compliance. The guidelines clearly mandate that intermediary must remove unlawful content within 36 hours of receiving notice. Yet, in the advocate's case, non-consensual videos portraying her in sexually explicit and vulnerable positions remain accessible across over 70 digital platforms, including Telegram channels, Google Drive links, pornographic websites, and social media platforms, with no meaningful or timely takedown response. Adding to the confusion, platforms often evade responsibility through narrow legal interpretation. In a 2021 submission before Delhi High Court, Google argued that it does not qualify as social media intermediary under the rules. However, Rule 2W of the intermediary guidelines defines such platforms as those that primarily enable user interaction and content sharing. Ambiguities remain with regard to services like Google Drive. These definitional disputes, combined with delayed platform responses, creates a chilling effect on victims, deterring many from seeking redress. The problem is further compounded by the growing sophistication and unregulated accessibility of generative AI tools and platforms like Midjourney and OpenArt AI that lack any built-in safeguards to detect, flag, or trace manipulated content. The absence of provenance data, metadata that could confirm whether media is AI generated, renders it nearly impossible to distinguish between real and synthetic imagery. Worse still, such manipulated content is increasingly monetized through subscription-based platforms, allowing perpetrators to profit while victims often remain unaware until the material goes viral or is flagged by others. This creates an insidious new form of digital violation, one that is difficult to detect, nearly impossible to prevent, and deeply challenging to prosecute under existing laws. Now, addressing these challenges demand a multi-pronged approach that combines stronger enforcement with technological reform and public engagement. Number 1. Enforcement of intermediary guidelines must be made non-negotiable. Regular audits, financial penalties, and even criminal liability for repeated non-compliance could serve as deterrent for platforms that fail to protect users. Number 2. AI developers must be required to embed provenance data, implement stricter access control, and establish real-time content monitoring systems. This is not just a matter of corporate responsibility, but a necessary safeguard against digital abuse. Moreover, grievance redressal mechanisms like I4C and National Cybercrime Reporting Portal must be seamlessly integrated with state police systems and staffed with trained personnel to ensure timely responses. Number 4. Legal reforms should be considered to revise sections of IT Act, especially Section 66A, 66E, 67 and 67A, to account for AI-specific misuse with enhanced penalties for both individual perpetrators and negligent platforms. Finally, public awareness must be made a national priority, and there is a need to expand campaigns through multilingual materials and integrating digital literacy and cyber hygiene into school curricula. This can equip citizens, especially women and youth, to better protect themselves and report violations. Hence, the onus is now on the government, technology firms, intermediaries, and civil society to act swiftly and decisively. The digital space must not be allowed to become playground for impunity. Only through coordinated efforts, robust safeguards, and unwavering commitment to justice, we can ensure that technology remains a force for empowerment rather than exploitation. Thank you for tuning in to Unwiring Tech.